Dr. M. Thambidurai. Sir, you know very well the land is the real wealth of our country. Persons. Our farmers are fully depending on the land. They are cultivating for their livelihood. They are for centuries onwards, if you take, the farmers are fully on the depend on the land and they are cultivating and they are living on the livelihood. Sir, when the land is so precious, at the same time, government wants to regulate to protect the farmers. That is the issue. If you take, for example, the government of India is making an attempt to replace the Colonial Era of Land Acquisition Act 1894 with the Land Acquisition and Rehabilitation Resettlement Bill 2011. Sir, in this connection, I want to say, even though they are going to protect the farmers' interest and the landowners' interest, but the class, what they mentioned regarding the 38 class, that is page number 17, if you go through, that gets urgency. The urgency class, what they're telling, in the urgency class, government can acquire the land for any purpose. At the same time, we have to, without following any procedure. That is what the urgency class says. The urgency class, if they apply like that, the real farmers will be affected. The property right, the legally which they are having for many years, by using this class 38, the poor farmer is going to lose that his right. He cannot appeal. For therefore, what I am requesting you, please give the protection to the farmer. This kind of is a legal right. That legal right must not be taken away. What demanding, sir? In this connection only, our Honorable Chief Minister has written letters concerning the Prime Minister and others, and also she expressed her concern regarding about this bill. Because this bill, when we are in this present form, even though we are claiming as going to protect the farmers and other landowners, actually there are so many flaws in that which affects the landowners and the poor farmers. Therefore, we have to give adequate caution and include certain clauses which are necessary to protect the rights of the farmers, sir. First of all, I want to say that land is a subject of state, the state subject. That you have to give some guidelines if you feel that let the state governments make legislation according to the requirements of the acts, if you feel that. But you are entering the domain of the state government. Already you brought the bill, it's a food security bill. Many state governments are implementing the scheme successfully in Tamil Nadu. But now the same way, for your interest and for your election manifesto, somehow you want to bring this kind of legislation, which is the domain of the state government. Therefore, we are objecting in that context only. Second, sir, regarding appropriate authority. See, whenever you are telling appropriate authority means, you are, in many places you are telling about the central government. See, land, when you are acquiring, you have to get the consent of the state government. The state government is definitely, they will do whatever the central government require at that time to acquire the land. But for example, for union government, if you are taking anything, it's all right. But even for PP projects and even certain private companies, if they want land, at that time also, you are going to interfere in that. And also when two states are involved, when you are acquiring land, at that time you cannot use the appropriate as a central government. Let you approach both the state governments. And even some more, not only two states, even three states are involved, means you have to respect them and see that state government's concern you have to get, then only it will be appropriate, sir. That is what we are telling. Second, regarding the statutory bodies, sir, if you take, there are class 2 currently mentions only appropriate government, private companies and public PP projects. there is no clarity to whether local bodies, statutory boards, public sector companies, universities, etc. would be covered within the definition of appropriate government or not. This needs to be clearly provided for the prevention of litigation. And also, sir, when you are acquiring the land, a standing committee made some observation. You cannot, for acquiring the land, you cannot apply everything as it is equivalent to government. Suppose state government, central government acquiring land for public purpose means that is all right. But private companies or some kind of other purposes, if they are allowing same class if you append, which is not correct, sir. Therefore, the principle of eminent domain should not be invoked for a land purchase for private companies. When you are that same class, you cannot be used for private companies. The public purpose is different. Public purpose is when you cannot equate to the private companies to acquire the land which we want to express our views, sir. Therefore, class 3 ZA, in section ZA, is bound to become fertile ground for unnecessary litigation and the deemed public purpose under the subclasses 1, 2, 3, 4 and 5 are also likely to be needlessly questioned as to whether they amount to public purpose or not. Therefore, we object the class 3 ZA of the bill. So, and regarding a social impact assessment, see, all right, for 50 acres may be prescribed for appraisal of the SA. The other, suppose state government acquired some land for public purpose. At that time, this clause must not be applied. Otherwise, it will take long time to implement certain projects, sir. Second, clause 24 provides for lapsing of the land acquisition proceedings initiated under the earlier LA Act, where awards have not been passed and requires the fresh initiation of LA proceedings. This could cause considerable delay in the process and stall the state government projects. Therefore, we object the clause 24. So under the very restricted definition of urgency in clause 38, which already I explained to you, to defense of India or national security or for any emergency arising out of natural calamity appears to be very restrictive. The urgency provisions can be extended to some critical infrastructure of the state government projects also, which are required. Clause 98 and 4th schedule protection, sir. Under the class 98, 16 Central Acts, which allow for acquisition of land, have been placed in the 4th schedule, and the acquisition of land under these provisions have been made exempt from the application of LAR bill, although based on Parliament Standing Committee's observation, a provision has been made to extend the provision of compensation and research and rehabilitation packages under the LAR bill to acquire under exempted acts by specifically notification. Sir, and one thing, sir, we had a better experience in Tamil Nadu. For GAIL, regarding for the petroleum ministry, you also include in the class to acquire the land. When already lot of agitation in Tamil Nadu, when the petroleum minister wanted to take the land to lay the gas pipelines. When we are doing, even though you are putting in it, the utilization of the land goes down. Therefore, we are asking to exempt that class. Otherwise, the farmers are affected because of affecting a lot of agitation is there. Therefore, we have to face the state government has to face the problem. Therefore, we are requesting the Honourable Minister to see it has to be deleted in the class. Regarding national monetary, sir, and also state acts that provide for acquisition of land like the Tamil Nadu Highways Act 2001 and Tamil Nadu Acquisition of Land for Industrial Purpose Act 1999 should also be given the protection of class 98 and included in the 4th schedule. This is what it is. And also monetary class, we have said classes 4 and 43 provides the established monetary thing. National Monetary Committee. Sir, National Monetary Committee can look after regarding your central things. At the same time, state must be given power to monitoring the other projects. You cannot apply the same thing for the state thing. That is what we are requesting. That has to be deleted. Regarding the compensation, when you are telling compensation you are giving, at the same time, we want to see that whether you have mentioned in the rule they can be given land or money. Sir, we are requesting let the land has to be given for land because the farmers are interested to have the land. And also you are telling the land bank. I don't know what is the instead of land bank. If you are having land bank, at the time what will happen? The land will be kept in the land bank. At that may not be utilized sometimes. Therefore, what we are suggesting, whenever you are not utilize the land, if you acquire more period, let the land must be given the farmers immediately within short period. It must not be kept for long period under any, not this means, sir. Regarding when you are paying compensation, the interest you have paid only 12% you have mentioned. What we are requesting, let it be not 12%, it has to be enhanced to the 15%. Then only we include the farmers. It will be helpful for the farmers. Sir, these are certain amendments already we have given. I request the Honorable Minister look into the apprehension what we have raised and the concern raised by our state government that has to be addressed properly. Then only it will be useful. Therefore, when you are replacing the old act, when you are bringing new bill, that must be more beneficial to the farmers. Because some of our members mentioned that when we have to protect the irrigated land, then what about the dry land? Sir, nowadays, dry land is more costly because the farmers not able to do the cultivation. They are suffering a lot because due to the government policy, central government policy, they are not able to give more attention to the agriculturist. At that time, because of the failure of monsoon, most of the farmers are suffering in India. Therefore, when many calamities taking place also, when our state government requesting to help the central government to help compensation, they are not coming forward. The farmers are suffering. Therefore, most of the farmers, even wetland they are having, they are not in a position to cultivate the land. They are suffering a lot. But therefore, when you want to really protect the food security bill, what you are already introduced, to see that food can be produced more and that will be successful, we have to give more incentive to the irrigated lands for the farmers. That way only you can protect. Otherwise, even you putting a class, you want to protect the food for the food security, to protect the irrigated land. At that time, what are the incentives you are giving? That their farmers are suffering. Therefore, that suffering has to be removed. For that, government has to come forward a new scheme and help for the farmers. Therefore, dry land, even the dry land, once upon a time, nobody is interested to have the land. They sold with the lower land. Now, that the dry land cost is increased because it tempts the even irrigated land farmers also to go sell the land. That kind of is there. Therefore, really, if you want to protect the farmers, the central government come forward to give finance assistance and also give the minimum support price to be increased. Then only the farmers will come forward to cultivate the land. These are the things I want to say.